Yeah, it's good now. It's good. Yeah.
Oh, okay.
Okay.
So you're trying to get to the specifics of what happened on a different day. So you say you already know that she remembers June 5th, or at least she testified to that, and that was a Wednesday. Now you're trying to get, and then you also know that she was injured. What would be your next question?
How were you?
Right, but that's a little vague, isn't it?
What part of your body was injured?
That's good.
No, because that's assuming, that's speculative, because it could have been her.
She just said she was injured. That's not speculative.
Okay.
You're laying a foundation for what you're trying to get at, right?
Okay, yeah. Okay, so how were you, no,
It's hard, isn't it?
not, what kind of injuries did you sustain?
I got a broken nose.
Was that all?
Was that all? Again, vague and ambiguous. What do you want to get at, though? What do you know?
How was she?
You know she just got a broken nose, right? So why would you ask, was that all? So that was vague and ambiguous, calls for narrative again, which tends to be Jennifer's thing. Which is okay. You're very vague, Jennifer. You're very vague. You should be in the current administration. Then you can be vague about everything. Well, but that's pretty much every administration, I guess, right? Politics, vague.
Fine.
I wish we could object to politicians. That'd be great. So we already know she got a broken nose. Now what are we going to try to get at? What are you trying to get at?
Where did the injury occur?
How did the injury occur? So.
Well, where did it occur?
Right, but why don't you ask her, yeah, where did it occur?
What caused the injury?
And what caused it? Yeah, that's what I would get at.
Okay, so where did the injury occur?
That's vague and ambiguous. Where, does that mean her face, or does that mean the location?
Oh, yeah, okay. Do you want to rephrase that?
At which geographic location?
What geographic location did the injury occur?
In front of my yard.
Can you clarify?
Yeah,
Inside your yard?
Okay, well, hold on. You're saying in the front of the yard. What? You can now go further and say where?
Where in your yard?
Where in the front of your yard?
Where in the front of your yard?
Right in the middle, in front of my house, by the fence.
By the fence. That's what you
Yeah.
wanted.
Okay.
And then you probably want to get into how the injury occurred, but don't just say how did the injury occur.
Do you know how you sustained a broken nose?
Good question. Why can't that be objectionable? Because she said, do you know how the injury, how? That's a yes or no question. That's beautiful. That's how you lay foundation, people, is you say, do you know this? Because otherwise, the question could be objectionable. So I would say, do you know what caused your nose to be broken? And she said yes. And then you follow up with, what is it?
What caused your nose to be broken?
I was hit by a 2x4. It was flown from the other side.
Objection. Well, why am I saying objection now?
I'm giving too much.
All right, let me try to see if you guys can find this. Objection. Why am I objecting? Did she answer the question and kept going?
Yes.
Why would I object?
Cumulative?
What?
Cumulative?
No. This is an objection against the witness, not against you. Objection against the witness. They answered the question and kept going. What do you call that?
Beyond
Narrative?
Nope.
the scope?
Nope. Motion to move to strike is non-responsive. That's what I would say. Move to strike is non-responsive. Anything after she said, I was hit by a 2x4. Because why would I, as defense counsel, object right away when she started speaking off at the cusp? Because she could possibly start, I would stop her right there. When she said, I got hit by a 2x4. And by the way, I'd be like, objection, move to strike is non-responsive. She already answered the question. Why would I do that? Because Polly might go, oh, because he freaking pushed the board and hit me.
Yeah.
I don't want the jury to hear that. So I object right away. Move to strike is non-responsive. Then you move on.
when you say non-responsive, what's that actually mean?
It means that it's not, that she had already responded to the
Yeah.
question, right?
Mhm.
Yeah.
And that means anything she said thereafter is not responsive to the question. She already
Got it.
responded. She's going further.
Okay.
You've heard this one.
I've heard this one too, when I was on the stand.
Yeah, I'm sure you did, Mrs. Vague.
Very narrative-like.
Okay, so she just answered the question as to she got hit by a 2x4. Then go deeper.
Do you know
Do you know?
how the 2x4 struck your nose?
That's a great question. That's a yes or no question. I can't object to that. And oftentimes I'll hear counsel object to that, and I'll say, Your Honor, it's a yes or no question. I'm just asking her if she knows how the 2x4 hit her. I think that's pretty reasonable. And the judge would say, overruled. So, go on.
Yes, I do. It was.
Move to strike is non-responsive.
Okay, alright.
Can
Keep asking.
can I do that too as well? Because I don't want
You
to.
can, actually. You
Same
can.
thing, okay.
Yeah, because I've done that to clients all the time. I've done that to you. where in the middle of it, it's like, wait, I don't know where she's going to go with this, so move to strike is non-responsive. Shut up. Kind of thing.
Yeah, I agree with that.
But I can't say shut up
No.
to my client. I have to say it technically. So,
I had asked her.
so you asked her, do you know how the blah, blah, blah? She said yes. Next question. Know how the 2x4 came in contact with the nose? She said yes. Next question.
Can you please describe how the 2x4 came in contact with your nose?
Any objections?
Technically, it's a narrative, but
Calls for speculation.
Really?
she's not an expert.
But she that would probably be overruled. Let's see what how she can answer.
But in your opinion, 100%.
No, do you know how the board hit your nose? I mean, if it wasn't on the other side of the fence, she probably would know. If it didn't come from over the other side of the fence, she probably would know, because she could see it. Like if I come up and hit you, smack you with a 2x4 right now, Greg, and I ask you that question, do you know how you got hit in the head with a 2x4? You know, because I hit you in the head with it.
You're the cop that asked when you
But
went to traction.
this is a board that slid through a fence and hit Polly in the face, right? Does she really know? I don't know. We'll see. So ask the question, do you know how the board came in contact with your face?
Do you know how the board came in contact with your face?
It was thrown from the other side.
Yeah,
What the fact pattern actually said that it was pushed through a hole.
Oh
in
yeah,
the
it was
fence.
yeah, I was pushed through the whole of it. Yeah.
Yeah, she can't know for possible fact that you can't say absolutely it was thrown from the other side. She couldn't see the other side of the fence.
Okay, what's the problem with Greg's objection? It's not what's called a speaking objection. When you make it an objection, you have to do what's called a speaking objection, meaning you just simply say, move to strike was speculative. You got to say just a single word or a
I'll
single
explain
couple of
why it
words.
was objection.
The judge is supposed to understand where you're coming from, even though sometimes they don't. But you say calls for I would have said calls for speculation. The judge probably would overrule that. She answers. The board was, what did you say?
It was pushed through the other side and pushed through the hole from the other side of the
I would say a move to strike is speculative, Your Honor. And then she'd say overruled or sustained, and then I'd say if she overruled my motion move to strike, I'd say, Your Honor, how could she possibly know how the board came and hit her because she was on the other side of a fence? Then I'd explain it. Only when the judge overrules my objection, then I come in, I interject, and I say, well, Your Honor, because then I'm thinking maybe she doesn't get it. Maybe the judge doesn't get what I'm saying. Okay? Continue on. She said that, I moved to strike, the judge just said overruled, that question just came in. That answer came in. It was pushed through the hole in the fence. Which technically she could have figured that. Right? How else does a board go through a hole in a fence?
Do
Does
you
it
know?
magically,
Do you know what was on the other side of the fence?
David
calls for
Brooks?
speculation?
Did you see?
Actually, why would that be overruled? Somebody object,
It's a
calls
yes
for
or no
speculation.
question. Because it's a yes or no question. Does
Because
she
it's a
know?
yes or no, do you know? Yeah.
Yeah.
Just
Yes.
asking whether she does know. Then it's not speculative, is it?
Yes, I do. I do know.
You know what happened on the other side of the fence. She said
Okay.
yes.
Yes.
What's your next question?
Can you
I'm worried about any ambiguity here.
Can you tell us what you saw?
Yeah,
Yep.
she never said she
There it is.
saw anything. Assumes facts, not an evidence,
Okay.
misstates testimony. What you need to say is, how do you know what happened on the other side?
How do you
And then
know?
you lay that foundation for what she saw, heard, etc., etc. You're trying to get specifics, not opinions. You're trying to get facts, not bull. Okay, so so the next question is, go ahead and answer it.
I heard some banging noise as they were working on a fence, and so I want to make sure that part of my fence are not damaged.
Move distracted, non-responsive. Did she just answer the question of how she knew it was on the other side of the fence?
No.
No, she didn't answer.
Oh.
How do you know?
I heard the banging noise. So
Move distracted, non-responsive. But now I can answer the question again. I'm going to take over for you for 30 seconds. How do you know?
I heard the noise.
You
So
heard
the-
what noise?
Construction noise.
Construction noise.
Yeah.
And how did that lead to you to believing that the board was pushed through the fence?
Because it hit my nose.
There we go. But how do you know? How do you know? Well, let me step back. Were you? I'm being defense now. I gotta stop.
Because I think-
I can't help it. I can't help it. I just want to go. Go ahead. Go ahead. Keep going. So it hit her nose. She said, "Okay, this is all good for you. You want her to answer like this. You're the plaintiff's attorney."
Okay. Tell.
We already know that the board was pushed through the fence. We already know that the board hit her in the nose and that she got hurt, right? What else do we need to know here, John? Anybody can say this.
Who did it?
Who did it? What else do we need to know? So here's where we're going at now. Here's your line of questioning. Who? What else do we need to know?
Intent.
We need to get at intent. Were they intentionally doing it? So we're going to get at intent. What was it done intentionally? Yeah, Greg, I hope you're preparing a good cross on this.
Oh,
'Cause
yeah.
You're going to tear Polly up right now. Okay. Okay. So let's get into the who and the intent. And then what else are you going to need to know after that? You're trying to prove a personal injury case. First,
Yeah.
what's the first issue in a personal injury case is? Who done it? Causation, right? You need to connect the dots that this injury was caused by Greg's client. Secondly, what are we trying to prove up in a personal injury case?
Yeah.
Damages. So you're going to get into damages with Polly here. Okay? Go ahead.
Did you see any other person on June 5th at the time, near the time of within an hour of your injury?
Okay, what's wrong with that?
Like,
What
any
else?
other person?
What else?
And it's also kind of a leading question.
Assumes
too.
facts on an evidence misstates testimony because it says other person. We didn't know of any person other than Polly in the first place, so we don't have more than one person on the other side. It's speculative. There's a number of problems there. Just simply get to the point and say, do you know
Who did it?
who pushed the board? Who was in control of the board
Do you know who was in control of the board
when it struck
when it
you?
struck you in the face?
Can anybody object to that?
No, it's a yes or
It's
no.
a yes or no question.
Yes. I think so.
What's your next question?
How much do you think so?
Yeah, just who?
Who?
She says she knows.
Okay, who pushed it?
I believe it was Dave's friend.
Dave's friend.
Yeah.
No, actually, you believe it was Dave.
Oh, really?
Yeah.
Oh, I'm sorry. I believe it was Dave.
I wish the judge could do that. I wish I could do that.
How-
That's not what you're supposed to say.
How do you know it was Dave?
Because I heard his.
Yeah, I wouldn't answer that question. I wouldn't ask that question of plaintiff's counsel. So we say, oh, it was Dave. Now move on.